an attempt to hide or disguise money or funds obtained from a crime so that it appears as a legitimate assets. In Indonesia, I'm sure we all already aware of this. This crime is regulated to hide or disguise money. In Indonesia, this crime is regulated in Law Number 8 of 2010 concerning preventions and laundering crimes. Nowadays, the crime of money laundering is not only conducted within a country, it has been conducted cross-border, and therefore its eradication needs a cooperation from multi-jurisdiction. This afternoon, Dr. Prosper will deliver a lecture regarding Introduction to International Anti-Money Laundering Law. And money laundering has been the research focus and expertise of Dr. Prosper. So this lecture will be very interesting, and I hope we all can learn a lot from him. Without further ado, Dr. Prosper, if you're ready, you may start your lecture. Thank you.
Okay, thank you very much for this warm introduction as well as the brief remarks on anti-money laundering. If you can allow me to share my screen so that I can begin.
You may, Dr. Prosper.
Okay, sure. Let's see. There is the one. I hope you can see it now. Can you see my screen, everybody?
Yeah, we can see it.
Okay. Okay, that's good then. Excellent. Again, I'm just reminding myself I didn't greet the students. So again, it is really nice to be here, though virtually, and I'm hoping that we are going to have a fruitful, interactive session for the next 1 hour and so, 1 hour and a half, I believe. So allow me to first just let you explain briefly about the topic of today's session, an introduction to anti-money laundering law. So this is going to be an overview, a big crash course on the course or the subject of anti-money laundering law. It's a fairly new discipline. Not so much has been written about it. Only a few textbooks exist. Actually, this session is chapter 1 of a forthcoming textbook, my forthcoming textbook on anti-money laundering. So it is quite an honor to have this opportunity to do some sort of piloting the first chapter of my textbook with you today. You are the first students who you have the pleasure to review the textbook. So that said, let me just give you an overview of how the session is going to be conducted. So I divided this topic, what is an introduction to anti-money laundering law, into 4 sessions, 4 distinct sessions. The first one, of course, the basis. What is money laundering? Should be a question mark there. So what is money laundering? That's where we discuss the nitty-gritty of the crime of money laundering. So the elements, mental elements, also the physical elements, we also define them when we discuss when we define different crimes under money laundering. The second part will be the 3 stages of money laundering law. So in the second session, we are going to delve into the 3 separate stages that are key, believed to be key in a money laundering process in the commission of the crime of money laundering. And then not finally, the third one will be the other concept of money laundering. So some other not so familiar issues about the crime of money laundering. Maybe familiar to you, maybe to others not so familiar. So we also discuss how money laundering is related to other crimes. Its implications, this one is subject to the availability of time. I may delve or I may just discuss briefly the implications, and by implications, I mean the negative effect of the crime of money laundering. They are not very different from the implications or the effects of corruption we discussed last week. So I may skip this and refer you to my other notes, which I hope you received from last week. And then finally, some critical reflections. I've earmarked 2 most controversial subject about the law, money laundering law. So we are going to finish this session with a discussion. Maybe we can even go into breakout rooms and then just critically reflect on these very peculiar elements of the crime of money laundering. So I will not jump the gun and tell you at the moment. We'll find out towards the end of the sessions what are the critical issues. Perhaps some of you may even pick them up as we are, in the first, second, or third parts of today's session. All right, good. So we get started. The idea was to start with Padlet. This is just some interactive too, but I can see that our moderator already did quite a good job, discussing, also sharing, defining the crime of money laundering. So we'll skip this part of what is money laundering, unless, of course, maybe I don't want to restrict, unless if somebody if one of you wants to share a definition that they've heard about the crime of money laundering, or they have. Is there anyone who wants to share a different definition to the one that was already given by the moderator?
Kasih tahu namamu siapa dan apa pengertian setiap uangnya. Apa itu tidak
Check. Thank you. My name is Dharma Sahyan. The definition of money laundering, as the simple, is the turn of dirty money into clean money. Thank you.
Okay, that's a very simple, basic one. Thank you so much. A very good starting starting point. So let's review now the definitions that I've prepared. But thank you very much. It's also another exercise. I don't know how many of you, I know students, you like also watching. Why are my slides moving without me pushing anything? So I know students, you really enjoy watching series when you are not pressed with assignments or you don't have any due dates. How many of you have watched this series? One is called Pablo Escobar. Or ever heard about Pablo Escobar, El Chapo, or watched Breaking Bad? Well, I will not really ask you to raise your hands. Maybe you can raise your hands if you have watched this. I could see, because I can see also here. How many of you have watched any of these series? You can raise your hands. I'm not going to ask any questions. Okay, well, it's difficult to see, but I can see some few hands. Yes. Or who just have heard about these men? You've probably heard about Pablo Escobar, El Chapo, or Mr. Walter. Well, he was calling himself Heisenberg. But so the thing is that in all these movies, they actually portray real life situations. Pablo Escobar actually existed. He was a Colombian drug king. El Chapo was a Mexican, also drug king. One thing they had in common is that they were so successful in their illegal businesses that they generated so much amount of money. You've generated so much money, you cannot keep it under the mattress. You have to deposit it somewhere in a bank. But then there is a problem. The moment you try to put your money in a bank, then you'll face some questions, how you got the money, whether it's legitimate or not, and so forth. So all those who are involved in criminal activities, criminals basically, especially with criminal activities that derives or that can bring large amounts of money, like drug trafficking, they have to find ways of, making their money legitimate. And that process is what is called money laundering. An anecdote. is that, well, when drug kings like Pablo Escobar or El Chapo got money, what they used to do is that they would buy a laundromat. You know, a laundromat is a shop where you go and wash your clothes. So they will buy a laundromat and washing people's clothes, legitimate business. But in the process, they bring also money from their illegal activities and make it appear as if they are making so much money from their legal business or legitimate washing machine business. So that's why this crime is called money laundering, because the criminals were involved in buying laundromats. But that's just an anecdote. The thing is, money laundering is an old crime that has been with us since time immemorial. I don't know if you've heard about the word hawala. Hawala existed has been with us for centuries now, a method of moving money without actually making money move physically, crossing borders. But these are ancient ways of transferring money from one place to another, even illegal money, making it legal from the other end. The very basic definition of money laundering in literature is that it is used to describe a process, as the moderator said, and also as a student said, is the process by which criminals, they disguise, so the key word is to disguise the original ownership and control of the proceeds of criminal conduct. So that's another myth, that money laundering is not just about money. It can also be any proceeds of criminal activity. So it could be property that is derived from a criminal activity, and you go into a process of making that appear to be from a legitimate source. So it appears to have been derived from a legitimate source. So the key element here will be disguising. You want to disguise, you want to you are grouping the authorities and others to make your illegal sources appear as if they are legally earned. So this, in a very simple way, well, it was said much more simpler, but in another more simple way is the way you describe the process of money laundering, and henceforth the crime of money laundering. But of course, we are law students, so we refer to the law. What does the law say about the definition of money laundering? The first definition of money laundering was in an international convention. So money laundering is a crime that came from the international plan before the domestic level. Before it was implemented at the domestic level, the international community via the United Nations were already worried about this crime of money laundering, mainly because also it crosses borders, but we'll talk about that. So it's called the Palermo Convention. Because it was signed in Palermo in Italy. But the first convention, this was against transferring or trafficking, drug trafficking. It defines money laundering as the conversion or transfer of property, not only money but property, knowing, so knowledge is very key, that it is derived from a criminal offense for the purpose of concealing or disguising. So another two key elements, concealing and disguising its illicit origin, or it could also be that you are assisting a person who is involved in the commission of the crime to evade the legal consequences of his actions. Could also be her actions. So money launderers can also be women. So his or her actions. Well, the Palermo Convention was written at that time where people didn't really take this very seriously. Well, but we are still using it. So the key elements here are conversion. You can see there's conversion. There is transfer. There is concealing. And we talked about disguising. And there is also assistance. So from this definition, you can derive 4 different types of the crime of money laundering, and I'll go into them. So, but before that, it's important that I mention that, although we have these 4 different conducts that states are encouraged, actually now forced to implement, to criminalize, states like Indonesia, the United Kingdom, the Netherlands, where I am, any other country in the world, they are now under obligations to criminalize these 4 different aspects of money laundering. In each jurisdiction, should you have a principal law that criminalizes money laundering. The mental element that is required is not identical in all 4 of them. So there are different sort of required mens rea, mental element, for each one of these different crimes. But key words are that, the suspect or accused person must have suspected that he or she is dealing with the proceeds of crime, or has knowledge that they are dealing with proceeds or money from a criminal offense, from an offense, or even reasonable grounds for suspicion. So it doesn't have to be a real suspicion or real knowledge. It can also be inferred from the objective standard that if you are a reasonable and average person, would you have thought that this is stolen money, or this is property that may have been derived from a criminal activity? So that also suffices. So you can see that money laundering, the mental element is quite broad. So it's almost like a strict liability crime. You have to actually have the knowledge that you are handling stolen property. If you receive this book from me in a way that is dubious, let's say I give it to you at night or so, under the cover of darkness, I don't want people to see, then you should have some reasonable suspicion that, why am I trying to hide it? Then I may have not acquired it legitimately. So these are some of the mental elements and how it varies between the 4 different types of crimes. Now let me go into the crimes, then you will understand the mental element. If you have questions, you can ask me after I go through all the 4 different kinds of the crime of money laundering. I believe I may be speaking a little bit too fast because I can't see you. So let me also remind everyone here that, please, if you do have any questions, right? If you have any questions, if you want me to repeat what I'm saying, or you want to add something that's important, you think, oh, this is very important, I want to add to what the lecturer is saying, just raise your hand, and I'm going to be assisted here by our moderator. You can assist me if there are some hands up in the gallery, because I'm not able to see. I have a blind side. I'm only looking at my slides. And I think there are others joining online also. If you do have something, you can just use the chat box, okay? So let's make this interactive. I don't want it to become too boring, like a session, lecturing. If you have anything, anytime, let's discuss it. All right, let's come back to the lectures. So as I was saying that, is this the one? I think this is the one. Yes, we were at the elements. So we discussed the process of that money laundering is a crime that arises out of, the need to disguise illegitimate sources. A criminal is very successful in what he is doing. He has acquired so much money, but spending it is a problem. So they have to devise methods of enjoying their money without raising the suspicion of the police or other authorities fighting crime. So they have to come up with ways of making their money legitimate. And one of the ways, if true or false, was to buy laundromats, and then you appear as if you are cleaning people's clothes and getting, it's a successful business. And they were in the process also, sneaking in their illegal money. And that's why it's called money laundering, but also for many other reasons, also because it's cleaning dirty money. So stolen money is considered to be dirty money, blood money. So it needs cleaning for it to be usable. So that's also the other reason why we call this crime money laundering. And as I also mentioned, that if you look at the law, the first law that criminalizes money laundering, the United Nations Convention Against Drug Trafficking, otherwise known as the Palermo Convention, it distinguishes money laundering into 4 different crimes, which states are under an obligation to criminalize. And for these different crimes, it's important that we know as law students, who one day may also be defending money launderers, that there are different mental elements that are required. The physical element with money laundering is quite clear. It's the possession of the stolen property, stolen money. The mental element is more important. It is that either you have suspicion, or you have knowledge, or you have reasonable suspicion or ought to have known that you are dealing with the proceeds of a crime. And now to understand this much further, we go to the first one of these primary money laundering offenses. These are called conversion or transfer offenses. So if you are involved in the conversion or transfer of property or money, and knowing that such property is proceeds of a criminal activity, with the purpose that you want to conceal or disguise it, then that's the commission of money laundering. So the predicate offense may be something else, and I'm going to discuss this. Sorry about that. I've already started throwing some big words without defining them, but we will discuss very soon what is a predicate offense. Okay, but so what I want you to understand at this stage is that the first one is conversion or transfer. So by conversion or transfer, basically we are saying that you are taking some proceeds of crime and you are moving them. So you are converting them into something else, or you are transferring them from one place to another place where they can be enjoyed or away from the criminal activity. So that's the first part of money laundering. That's the first type of money laundering offenses. The other type of money laundering offensive involves also concealing and disguising. So it's a bit confusing because also with conversion and transfer, the element must be to conceal and disguise. So if you just move property from one place to another without that element to conceal and disguise, that's not money laundering. So there must be the element of concealing and disguising the proceeds of crime. So you are trying to hide them. That's the word concealing. To disguise, to change the form. You want to change everything to make them appear as if they are not even connected to the criminal offense that you have committed. So the concealing and disguising, there must be intention. The mental element here is the intention of the accused, that they should have knowledge or suspicion that the property constitute proceeds of crime at the time of the act. So that's what the police officers will be looking at this intention, the mental element. Do you have knowledge or suspicion that you are concealing or disguising proceeds of a crime? So these are the second types of money laundering offenses. The second type is concealing and disguising. First type is conversion or transfer. Second type is concealing or disguising. Anything that is involved with concealing or disguising the proceeds of a crime should be criminalized as money laundering. Any activity that will result in concealing and disguising property that is acquired illegally should be criminalized as money laundering. The third one is acquisition, possession, or even use itself. Quite interesting here. Already some problematic issues here. So if you acquire or you possess, simply just having it in your bookshelf, if you have a stolen book, that can also be regarded as money laundering. But what's more, even using a property or money that has illegal origin can also be regarded as money laundering. Of course, if you are doing this with the intention to conceal and disguise. But with this special crime of money laundering, the mental element here that is required is that you should have actual knowledge. So here, well, they don't talk about just, intention. It's not about your intention. It's about the knowledge or suspicion at the time of acquisition or receipt of the property that it is from criminal proceeds. I hope that this is making sense. Huh? I'll try again to explain the three crimes that I've identified so far. Remember, the first one is conversion or transfer. So you receive property and you try to convert it or transfer it. That is money laundering. The second one will be disguising and concealing. So you receive property, you try to disguise it, you try to conceal it, to hide it. That is also money laundering. The third type is the acquisition, possession or use. So acquisition is to acquire. You acquire something, you possess it, you have it with you in your custody, or you're using something that is of illicit origin. That can also be classified as money laundering, which makes it very, very difficult now, because I am going to discuss this in the final part. if a criminal he has stolen something, let's say a car, the whole idea is, of course, they may want to use it, or they may sell it, to somebody, or they may just decide that I'm going to keep this car. I like it very much. I've stolen a really nice car, or I've stolen a really nice mobile phone, and I want to use it. So can that person be charged with stealing the phone and at the same time with the crime of money laundering? Because they have stolen a mobile phone and they are also using stolen property. That's a very tricky question that we want to reflect it towards the end. So I'm just explaining this at this slide because I want you to keep this at the back of your mind, that money laundering can be committed by a person who has committed the original offense. So the drug trafficker who is involved in, in trafficking drugs can also commit the crime of money laundering, or somebody else who is assisting them with moving their money or with hiding their money. They can also be arrested, charged with the crime of money laundering. So the other one, the first one, where the person who has committed the actual crime is also charged with the crime of money laundering, that's called self-money laundering or self-laundering. And when you are involved in the laundering of other people's ill-gotten gains, then that's third-party money laundering. And I'll go into the next slide, which discusses a little bit on that part. So this is called participation. So you associate, or you conspire with others, or you even attempt with others, or aid them, you abet, you facilitate, or counsel them in committing the crime of money laundering. So in this case, you may not be involved in the original crime, which I said is called the predicate offense. And I'm going to explain what's the predicate offense very soon. You are not involved in that part, but you, in the process, you assisted them moving ill-gotten gains, or you assisted them with ideas on how they can easily get their money into a bank and withdraw it in Jakarta and then use it to buy whatever they want. So that's also the crime of counseling. It is also a primary offense under the category of offenses that are defined as money laundering offenses. So money laundering, to sum it up, the crime of money laundering does not define one crime. Like the crime of corruption we discussed last session, the previous session, we said corruption does have different acts that are regarded as corruption. Could be bribery, it could be embezzlement, revolving doors, and all the other different crimes that are defined as corruption. There is no agreement, consensus when it comes to the number of offenses that can or should be defined as corruption. But in money laundering, luckily or fortunately, we do have the international community has agreed on these 4 principal offenses. Okay, good. So I feel like I've talked a little bit too much here at the moment. So I want to stop sharing again and get back to the session. Yes, I can see everybody again. So, okay, I see myself when let me remove the pin. Oh, yes, good. Thank you very much. Yes, now I can also see the students. So is it clear? Are we all clear about the crimes that are defined as money laundering? Who wants to volunteer and just state the 4 crimes that I mentioned fall under the crime of money laundering? Any volunteer? I don't see anybody coming up. All right, so let me just then, okay. Let me emphasize this again. So we said money laundering as a crime is actually a generic term that describes these 4 different crimes. And these are so there are different mental elements required for each one of them. You will see the slides and you will read maybe for the second, third time, you begin to appreciate and understand different crimes discussed under the generic term money laundering. Okay, I will share again my screen and let's see what we have. Okay, so we proceed here to the 3 stages of the crime of money laundering. So money laundering is believed to have 3 stages. I wanted to play a video, that's why I left it blank, but I'll just go straight into the description of the 3 different stages. So for a crime of money laundering to be said that you have been committed, we look for 3 different stages. They are not as clear as I mentioned here, or as William Rosenblatt, the US Customs Commissioner, who is believed to have coined this money laundering trilogy, suggested. So he suggested that the process of money laundering, the process of disguising and concealing the proceeds of ill-gotten gains involves 3 main stages. So in our mind, we want to have this mental picture of 3 stages that are involved in committing the crime of money laundering. The first stage is what is called placement. So from the word itself, placement, you place something. So this is, it represents the first stage in the washing of dirty money or proceeds of crime in the financial system. So this is where the criminal or a person representing the criminal places money or proceeds that have been acquired illegally into the formal financial system, into the legal financial system. It serves 2 purposes. The first one is that it relieves the criminal of holding or guarding large amounts of bulk of cash. So imagine a drug dealer who have money in different denominations. They will have coins, they will have paper, banknotes. In a true story, Pablo Escobar, I showed you in the beginning the picture of Pablo Escobar. They used to generate so much money that they will fill up a room the size of my study with money. This is nothing. They would fill up warehouses. El Chapo would have warehouses where they fill in money in big containers, in big bags. People are employed with counting machines to count money that was coming in. So it involves bulky cash of money. And by bulky cash of money, we're really talking of serious money, money in large volumes. So this is a risky business. This is risky for the criminal. They don't want the police officers to find them with such large amounts of money, which they keep in what they call stash houses. They have the separate house where they keep the drugs, a separate house where you keep your money. So these are really large volumes of money, and you want to get rid of that money as soon as you can. So this is very important stage in money laundering. It's called placement stage. We also call it the chokehold, chokehold, because the criminals are at the most risk of being caught. If you are caught with 10,000, you have to explain where you got 10,000 from, or with $5 million cash. Then you have to explain to the authorities, where did you get $5 million cash, especially if you don't have any other legitimate source of ways of earning money. The second reason is that why the purpose of placement is that it places money into the legitimate financial system. Yeah. So when the criminal is holding money in their stash house where they keep their money, or in a bunker somewhere, or underground in some big containers, they can risk anything happening to money. You want to put that money in a proper legitimate financial system. In the event of inflation, in the event of anything, that money should be safe. So that's why it's important. Even criminals also need banks. Other criminals can buy banks. They can afford to even buy banks where they can then, of course, launder their money. So this is the first stage. I don't know if you have any questions about placement. You can always raise your hand, and then we'll be alerted if you have questions about this first stage. The second stage is called layering. So also again, from the word to layer something, you are layering like you are making a pattern. So this stage follows usually follows placement. You place your money, a money launderer is placed his or her money in a formal financial system in a bank, and now they want to distribute that money. It's also called structuring. So you want to separate that money from the illegitimate source. You don't want that money to be associated with you as a criminal. So you start sending that money elsewhere. You deposit it into other accounts, bank accounts in foreign states. You deposit the money into other vehicles. Maybe money is deposited into a trust account that has no names, that links you to the criminal offense. There are different ways of layering, but basically it's getting that money far away from the source, from the original criminal source. So this is called the layering or structuring phase. Usually involves sending money into other bank accounts, sometimes also out of the country. You send your money into those countries that have secrecy, serious banking secrecy, like Switzerland. The Netherlands is also a secrecy haven, or you send it to other small islands where no one can get to know who owns this bank account. The bank account would simply be in numbers. So that's the structuring phase. And the final phase, before I go to the final phase, the other reason why the layering stage is important is that it makes it sophisticated for those who are fighting crime to follow the transactions. So money leaves a trail, what we call footnotes. And there is a common phrase in financial world parlance that you follow the money. So if investigators are investigating somebody for money laundering, they use this method that is called follow the money. Money leaves a track. You put money in a bank, there is a receipt and your name is entered. You transfer that money somewhere, there is also a trail. So in order to make that trail very long or even complicated, you structure your money in such a way that it will be difficult to follow where the money eventually ended. So that's why this stage is also very important for criminals, the layering stage. So they employ people, accountants, they employ bankers who can give them advice on how to make sure that they can conceal the proceeds of their crime. And now the final stage is called the integration stage. Or sometimes I call it a reintegration, because this is where the criminal is reintegrated with his or her proceeds. So this is where you get your money back clean. So your money entered the financial system as from illegal sources as drug money. In the placement stage, you layer it, you structure it, and it comes at the end clean. So you reintegrate with your money. This is where you are now free as a criminal to use your money. You now use it to buy houses, real estate, cars, anything. So this is where the criminal will enjoy their money as legitimate money. So that money can come back to them in the form of all sorts of ways they can come up, infinity. The list is endless. You can have the money back as pension money. You can have it as insurance money. You can disguise that you are receiving it as a donation, all sorts of ways. Criminals can even set up charities where they pretend to be donating money to so and so, yet they are just giving money to fellow criminals for the job they have done together. So there are endless ways in which money laundering can happen. And by the way, when I'm saying money is entering the financial system, there are also different ways in which money can be placed into the real financial system, including also via lawyers. As lawyers, we also help our clients sometimes with buying properties. So a criminal can come to you with ill-gotten gain money that has been illegitimately acquired, and they place it in your possession. That's already the first stage. The second stage is when you, as a lawyer, you now send this money elsewhere or into another account. That's already layering. Sometimes it's not so clear, but then there's the integration when you buy maybe a house on behalf of your client. You can just go from placement to reintegration. So these three stages, sometimes they are quite connected, but in an ideal world, this is how money laundering process works. So it has these three stages. You place, you layer, and then you reintegrate with the proceeds of crime as legitimate sources at the end of the chain. So these are the three processes of money laundering. Before I go to the other concept of money laundering, again, I will stop sharing. I'll stop sharing my screen and I want to come back to the room and see if we are still there. Are we still there and are we still following? Any questions so far? Do we have questions based on the two sessions? The definition of money laundering, the crimes, the elements, also the three stages of money laundering. Can we explain the three stages? We need a volunteer. Can somebody just explain the three stages of money laundering, please? Do I see a hand up? Oh, there is some technical problem. Okay, I guess nobody's has the guts to share or to. Okay, there's no volunteer. All right, so let me just summarize and then we come back to my slides. So as I said that money laundering can involve these three distinct processes. So you placement, layering, and reintegration. So these are the three main processes that are involved in the crime of money laundering. And I've shared in the slides, you can then also read in your own free time. Maybe it will become much more clear. So we come back and talk about the other concepts of the crime of money laundering. These concepts, I emphasize on them because to the best of my knowledge, I don't know of any other crime that is linked to other crimes like the crime of money laundering. So the crime of money laundering is so much linked. It's the mother of crimes, for lack of a better phrase. I want us to look at the concept of money laundering from 5 different other crimes. The first one is terrorism or financing terrorism, which sometimes is known as reverse money laundering. I want to look at the relationship between money laundering and corruption. And thirdly, I want to invite you also to look at the issue of predicate offenses. So we talked about money laundering being a crime that is committed by someone who may be concealing, disguising, transferring, or assisting a person who has earned property or money from committing a crime. But which crime are we talking about? So what crime or what are the crimes that can then lead to the generation of proceeds that will then lead to the crime of money laundering? And the fourth one is the crime of proliferation financing. It's a quite tongue-twisting word, proliferation. And we'll talk about proliferation financing soon. Pardon me, when I'm saying this word, it's very difficult for me because in my mother tongue, we don't have R. So it's very challenging when I have R and L in the same stem. Then the final aspect is money laundering and the asset recovery, money laundering and international asset recovery. This one is not a crime. It's also another counter way of a counter method to crimes such as corruption and so forth. So this is the context in which I want us to understand the crimes of money laundering. Those 4 different crimes we mentioned that can be committed in that trilogy, we also mentioned the 3 stages, is related very closely with these 5 other concepts that I want us to just have a brief look at. So the first is financing terrorism or terrorist financing. First, what is a terrorist? Who is a terrorist? Who wants to answer this one? I will not let you go on this one. Let me stop sharing my screen. I want to come back to the session. What is terrorism? Or what's a terrorism financing? I really want somebody, or I can just ask for a list of names of students and I will pick somebody. So to save you from the random picking, anyone who wants to be the hero of the class, and
Prosper,
define
maybe
to
you
us.
can pick. Maybe you can pick a color, and the persons who use that color should answer your questions.
Yes, okay, so I'm wearing gray and white. Anyone who is wearing gray, a gray, let's hear from a lady, a gray hijab.
Oke, silahkan yang paling depan,
Paling depan yang jilbab.
yang jilbab abu-abu, silahkan.
Apa itu
What's terrorism? Yeah,
Menurut
and terrorism
saudara,
financing. There are still too many people wearing grays. I see they are pushing each other. All right. Yeah, we have the speaker.
Baik, perkenalkan nama saya Nurul Aufa. Terorisme adalah perbuatan yang menggunakan kekerasan atau ancaman kekerasan yang menimbulkan suasana teror atau rasa takut secara meluas yang dapat menimbulkan korban yang bersifat massal dan atau menimbulkan kerusakan atau kehancuran terhadap objek vital yang strategis. Terima kasih.
siapa namanya tadi? Alpha. Nurul. Okay. So Prosper, according to Nurul, she said that terrorism is basically something regarding something using violence and its impact causing a massive impact towards a lot of people.
Ngomong aja.
Okay, do we all agree?
Yang lain mungkin ada definisi yang lain? Silahkan. Ya, yang baju abu-abu juga, baris ketiga. Ya, yang balik ke depan silahkan. Tidak harus menurut Google ya.
Let's ask the gentleman wearing a checked shirt. I see a gentleman with a checked shirt in front.
Oh, oke.
Right? Yes.
Ya, silahkan.
Baik, terima kasih atas kesempatannya. Jadi nama saya Muhammad Alif. Jadi menurut saya itu teroris itu penggunaan kekerasan untuk menimbulkan ketakutan dalam usaha untuk mencapai tujuan. Terima kasih.
Okay, so according to Alif, it's quite similar but has a little bit difference. He says that it's a violence that aims to cause a scare among the people to achieve a goal. Yeah.
Exactly. Well, that's also very good. Thank you so much, Mohammed and Narut. Very good definitions. I'm also quite surprised, though, that we seem to agree on this because in real world, there's really no proper agreement on the definition of a terrorist, and also what is terrorism. There is actually a saying that one man's terrorism is another man's freedom fighter. So when you say, oh, they are achieving this or they are using violence to others, they actually, that's the other only means we have to show. But whatever it is, there are, of course, ways of defining. At least international law has defined what acts are regarded as acts of terrorism, you know, causing unnecessary scare, harm, and all that. We know very common definitions where people, or acts of terrorism, people bomb or places a bomb in a train station or in a building, or they drive a plane into a busy street, or drive a truck into a busy street. All those are different types of terrorism, which is illegal. The end is illegal. It's murder, mass murder. People die in numbers in some cases. Okay, let's go back to the slides, and then I explain what I want to say about this crime and why we call money laundering reverse terrorism, or terrorism reverse money laundering. So the two, money laundering, as I said, the funds are raised from illegitimate sources like drug trafficking, human trafficking, or corruption is also another crime. But with terrorism now, the reverse is usually the case, that it's legitimate money, like personal donations, profits from real businesses or charitable organizations, that is used to commit crimes, you know, crimes of bombing stations, sabotaging, and all other crimes that are listed as terrorism activities. So there is the reverse of money laundering, although of course terrorism sometimes may also be sponsored by illegal money, but in most cases it is money that is legitimate but is used to commit an illegitimate end. So there's something in common between these two crimes, money laundering and terrorism. They both involve the movements of funds, of money, with minimum scrutiny to disguise the origin or the destination. So with money laundering, you want to disguise the origin of the money, that the money is coming from drug trafficking. With terrorism, you want to disguise the destination of money. So you pretend you are donating money for a reasonable cause, for a charity cause, sending children to school, or, you know, helping with some community activities, when that money is going to be used to buy material to manufacture a bomb that can be used to commit acts of terror. So this is the relationship between and the similarities between money laundering and terrorism. Good. So more I can explain in the forthcoming textbook, but today I just thought I would just share with you that interesting link between money laundering and the crime of terrorism. The second one is corruption, because sometimes we have people finding it very difficult to distinguish between money laundering and corruption, also because the two are mutually reinforcing. So usually where you have money laundering, you have corruption, or where you have corruption, you have money laundering. They work hand in glove. They are like yin and yang, you know. There's day before there's night, or there's night before there is day. So money laundering or corruption is a crime that really generates large amounts of money. Also generates money in a way. And a corrupt person would want, of course, to make that money appears as if they've earned it legally, or whatever proceeds they get from corruption. So this is the relationship between the two. So significantly, it's usually that the presence of one tends to produce the other. There is a reciprocal relationship between money laundering and the crime of corruption. The two always goes together. So you will see that international conventions against corruption, they have specific sections on money laundering, by the way. Also, those international conventions on drug trafficking, there's not yet an international convention on money laundering, but those that deals with drug trafficking, trafficking in other, you know, in psychotropic substances, they also have specific provisions also to deal with corruption, because corruption facilitates money laundering. And money laundering also in the end facilitates corruption. So it's like this unholy alliance, a vicious cycle. Once you're caught up in that process, it's very difficult to get out of it. The third one, we are going to talk about money laundering and other offenses. as I mentioned, that money laundering has to do with proceeds, money derived from other criminals, from other crimes or other offenses. So to put it in a more sophisticated way, not to confuse you, but in a very academic way, is that money laundering is conceived as a subsequent offense, or in Latin, delictum subsequens, which means that money laundering is after the commission of an original or previous offense, which popularly we call it a predicate offense. So before, predicate offense. So there must be another offense that you have been committed that has generated proceeds, profits, properties that needs to be laundered, to be made clean. And this delictum, this predicate offense is also known in Latin as the delictum principale. So the principal delict or offense. Delict is a wrongfulness. So the principal wrongfulness or the principal offense is committed, and then once that crime is committed, it is successful. I have lots of money with me. I've done a very good drug deal, and I have so much cash. And now I need to commit the crime of money laundering to process my money, disguise it, convert it to legitimate money that I can freely use without anybody asking me questions. Now, what is a predicate offense? I've explained to you that this is a predicate offense, but how do you identify a predicate offense? So international law does have different standards or recommends different ways of designating offenses as predicate offenses to the crime of money laundering. So states have a choice, basically three choices actually, not only one. So states have three choices to choose from. The first approach is called the inclusive approach. It's also known as the all crimes approach. So basically what states do is that they will say every crime is a predicate offense to the crime of money laundering. So if you generate money from the crime of murder and you try to conceal it, that is money laundering. If you generate money from drug trafficking and you try to conceal, to move it, transfer it, that is money laundering. If you generate money from some crimes of passion, these new crimes, you go on Facebook, you pretend to love somebody and they are buying you presents and all that. I don't know, in other crimes, this is now a crime. In other countries, I mean, it is now a crime to go on Facebook and you know those swindlers on Facebook, on WhatsApp and so forth, that can also be a way to generate money that also is regarded as a crime. So the all-inclusive approach, every sort of crime, whether it's adultery, as long as there is some proceeds from that crime, that should be regarded as a predicate offense to the crime of money laundering. Whereas in other countries, they've decided to have like a threshold approach. So this approach is where you designate a certain, you put a certain threshold, by saying, to limit the crimes that can be predicate offenses to the crime of money laundering. So you can say money laundering predicate offenses are only those crimes that attracts more than 1 year in prison, or that are regarded as serious offenses, or ones which if you commit, you are liable to pay a fine of more than 5 million rupees. This is a threshold. So you put a threshold, and then you have a category of crimes. And the third one is the list approach. So here you basically, lawmakers will sit down and they will make a list. Say, okay, if you commit the crime of corruption, that's a predicate offense. The crime of fraud, and the crime of whatever they put it, tax evasion. So they will put a list and they will give you the list in somewhere in a schedule. And they demarcate what are called predicate offenses. So these are the different ways in which lawmakers can designate a category of offenses that can be regarded as predicate offense to the crime of money laundering. As I mentioned, that one thing that is very, very peculiar and interesting about the crime of money laundering is that it is a crime subsequent, or it is a subsequent offense. It's a crime that comes after the commission of another offense. Maybe one last thing to mention about this is that if you are being charged, or an accused person is being charged with the crime of money laundering, the authorities do not need to prove the conviction or the commission of the delictum offense or the predicate offense. So we don't need to prove, as if I'm the official, there's no need to prove that the person has committed the crime of corruption. You can be charged and convicted with crime of money laundering, even without any a conviction of the predicate offense. So you don't need to be convicted of the crime of corruption first before you can be charged or convicted with the crime of money laundering. If there is suspicion that you committed corruption, that's already enough for you to be charged with the crime of money laundering and be sent to jail for money laundering or laundering the proceeds of corruption, even though you have not been convicted or charged with the crime of corruption. So what happens sometimes is that we have authorities, if they find it difficult to charge and convict somebody with a predicate offense, let's say corruption, they will then go for the next available charge, which is money laundering. So they will charge you with the crime of money laundering and send you to prison. And sometimes it's much easier if we look at crimes like drug trafficking, where it may be difficult to then really link the person to the drugs, but you find them with so much amount of money, they cannot explain it, and they are known to be connected with drug traffickers. Then they can be charged with money laundering on the basis that the proceeds, money they have is proceeds of the crime of drug trafficking. And the officers, the authorities, the prosecutor does not need to prove beyond reasonable doubt that the person is actually involved in drug trafficking. Very interesting. I'll come back and ask you, what are your thoughts in the critical reflection? Let me check the time. I think we're still doing quite well because we don't have many slides left. This is the latest addition to the crime of money laundering. As I said, the crime of money laundering is still evolving. About 20 years ago, we didn't have this crime, by the way. It only resurfaced very recently. So the crime of money laundering has now been added to include what is called proliferation financing. Quite a tongue-twisting word, this one. But also proliferation is also a fairly new crime. I don't know if it's already criminalized in Indonesia. It may not be in the criminal code as yet, but also that's the beauty of this course. In this course, we are also talking about crimes that may not be yet in the criminal code, but they are already recognized elsewhere. So proliferation financing refers to the act of providing funds or financial services, financial means to be used either in whole or in part for the manufacturing, acquisition, possession, development, shipment, all sorts of ways that are related to the use of nuclear, chemical, or biological weapons. So you are funding the making or the transfer, or you are funding the whole process of development of weapons of mass destruction, like nuclear weapons or chemical, biological weapons. And as you know, you ought to know, these weapons are in a certain way restricted. So chemical, some of them completely outbanned. Biological weapons are already, and chemical weapons, they are illegal under international humanitarian law. So they should not be used. Nuclear weapons, it's a political issue. Some countries are allowed to keep them. The rest of us, we are not allowed to keep them, okay? You can ask the US Embassy about that one. I don't have answers on this one, but we know that certain countries are actually on sanctions because they have developed their own nuclear weapons. North Korea, Iran is believed to be developing nuclear weapons. They deny it. Iraq was believed to be building nuclear weapons, but well, it also then came out that the information was wrong, but they were invaded anyway. So this one is a more political issue. But the fact is money laundering is also involved in this process. Why? Because, you know, money laundering is such a crime that allows the movement of money conspicuously. So nobody will know that the money is being used to develop a big weapon, because developing these weapons cost money, by the way. So those who are involved in the business of developing these weapons can easily mobilize finances without being detected. You know, if they use some of the methods that have been used, for instance, by drug traffickers to move their money across borders. Okay. The final part, which is the counter of money laundering, is asset recovery. So money laundering is now heavily involved with asset recovery. So we talked about criminals using money laundering as a way to enjoy the proceeds of their crimes or to transfer the proceeds of their criminal activities as far away from them as they can. You know, you push, you send your money to Miami, you invest it in Dubai, you buy nice condos, townhouses in other countries. Asset recovery is now the opposite. So it's a response to money laundering. This is where the authorities, prosecutors, they seize if they find any proceeds, any properties that may have been purchased using illegally acquired money or assets, then they have a duty to seize, you know, those properties, confiscate them, and return them back to the legitimate owners. So this is asset recovery. So money laundering and asset recovery are also quite related. You know, although they serve to, you know, different purposes. The other one is to kill, to conceal. The other one is now to make it right. You know, you are deconcealing what criminals thought they have concealed. You are now bringing it into the full glare of the public that, look, this is your money that has been stolen. So it's the recovery, the opposite part of of money laundering, which also has become very key these days when it comes to money laundering. So we talk also about anti-money laundering. Anti-money laundering is countering the crime of money laundering, and asset recovery is one of the key processes. Good. So let's come back here, and then we'll have the final 15 minutes and we'll be done. We aim to finish by 11:30, which will be 4 or 5 in Indonesia, in Makassar. Any questions, any contributions on the previous slides? The other concept of money laundering. Yeah, I see a hand. Ooh, we have a volunteer. Oh, several. Well, that's excellent. Good.
Okay, baik. Thank you very much. My name is Dharma Sahyan. Before I want to say sorry about my English is not too good, but I'm trying my best. The question is, as a follow-up to FATF recommendations regarding the formation of financial intelligence unit, the Indonesian state established its own of FIU name called Pusat Pelaporan Analisis dan Transaksi Keuangan, or PPATK, on legal basis law number 50 of 2002 concerning the crime of money laundering, which has now been amended into law number 8 of 2010. The problem with money laundering is currently of difficulty of proving to reveal what we call TPPU, or money laundering, due to the lack of evidence obtained by investigator. There is an issue that they say that to overcome these problems, the PPATK analysis report can be used as the initial evidence to facilitate the disclosure of money laundering. But what is also problems in the report of the result of the PPATK analysis as a confidential intelligence report. The question is whether intelligence report from an international perspective can be used as evidence or sufficient preliminary evidence to uncover money laundering. Thank you.
Okay, thank you very much. Yeah, by the way, I could understand very clearly. Yeah, the PPATK, Yeah, that's the FIU. I actually work with them in Depok and Jakarta several times. I've been at their offices. Quite interesting. Yeah. So evidence is always a difficult one to get when it comes to these crimes that crosses borders. So because money laundering, remember the second stage, we talked about layering. Layering sometimes involves sending money abroad, elsewhere. There is no other way of getting the evidence apart from getting it from your international partners. So the paper taker really has to rely on evidence from outside, and this evidence should be treated is given weight the same way you'd give evidence from locally that is locally available. In fact, in the international treaties and statutes that that I mentioned, there are separate sections on what is called mutual assistance. So states, they owe each other a duty to assist. They owe each other a duty to assist each other with information relating to money laundering and also corruption. So that evidence is important when it comes from outside. And in some cases, they also allow, suspend some confidentiality principles. I can give an example of domestic, but this one is domestic in the domestic arena. Let's say you are a lawyer, you graduate, you become a lawyer. There is an obligation for you under the Money Laundering Act in Indonesia as a lawyer. If you are working and you come across or you suspect that a client of yours is involved in money laundering, you are supposed to file a suspicious transaction report, a report with the perpetrator, and tell them that I think my client is involved in money laundering. There is an obligation for you as a lawyer, by the way. And in this case, even confidentiality, you cannot claim confidentiality here. But again, this is something that is only restricted to your other duties as a financial advisor. This is not related to your judicial business, representing a client in court. I will come back to that in the reflection section. But yeah, maybe I hope I've answered your question. International evidence from the international level is very important. There is something that is called mutual assistance. So countries owe each other a duty to help, in cases of money laundering at domestic level, at the domestic level. Thank you. I think there was another question.
Okay. Before it, my name is Nur Fatiha. Okay, sir. Before it, the conclusion that I came, if the money laundering is the process by which one conceals the existence illegal source or illegal application of income, and then disguises the income to make it appear legitimate. Okay, seeing this money laundering case was a little hard to handle. As sir said earlier, there is a layering, placement, and integration. So I want to ask about what is our role as students in responding to this edge of money laundering, considering the money laundering information was very messy. Okay, thank you.
Okay, good. Excellent. So as students, you are not going to remain students, by the way. In what, 3 years you are going to graduate? You become lawyers in different areas. I don't know who wants to become a prosecutor. If you can raise your hands, who of you wants to become prosecutors? Yeah. Okay, who wants to become a defense lawyer, criminal lawyer to defend? And who wants to become a judge or magistrate? I don't know what you guys are going to become. I'm going to be confused now. Okay, who wants to work with financial institutions like banks? A corporate lawyer? Who wants to work in a private firm as a general lawyer? Okay, I don't know if I can see, maybe my glasses are not working properly, but I don't see really some raise of hands. But okay, the point is this. In that class alone, in this class, we are all students today. In a few years' time, we are going to graduate. We are going to become judges. We are going to become magistrates. We are going to become defense lawyers. We are going to work in the corporate world as you know, those general counsels, counsel general, you know, the one who is overseeing the legal aspects of a big company, a bank. In all these different aspects, we will deal with the crime of money laundering. And we need to know the aspects, we need to know the elements of the crime of money laundering so that we give sound advice to our clients or to our employers if we are in full employment. This is one. Second, and very, very important, the crime of money laundering, the gentleman who just spoke, he told us that there is an act, the Money Laundering, Anti-Money Laundering Act or Proceeds of Crimes Act. He mentioned it, the specific title. He also mentioned the PPTK, the Financial Intelligence Unit of Indonesia. If you read this act, there is a provision there which says that certain professions, including the legal profession, and you are in the legal profession, they are supposed to assist the authorities in fighting the crime of money laundering. If they suspect or they have knowledge that their client is involved in money laundering, they are supposed to report that client to the Financial Intelligence Unit, the PPTK. So you as students, you are supposed to also know exactly what is the crime of money laundering, because when you finish your studies, you become lawyers, you are supposed to help with detecting the crime of money laundering. If you don't do so, you can actually be deregistered as a lawyer. You can also even be arrested for committing the crime of money laundering through counseling or assisting a money launderer. So this is why it is important for us as law students to be familiar with the crime of money laundering, because in our future work, we'll be dealing with money laundering a lot. And then of course, finally, and more generally, as citizens, we are responsible citizens, right? We should stop crime. As citizens, we have a duty not to commit crimes or to help others who are committing crimes. And criminals sometimes comes to lawyers so that they can be assisted in facilitating crimes. So that's why it's important for us to learn. Okay, I hope this is clear and we have answered your question. So now I'm very happy with this. It was a good, engaging and interactive, but I want to quickly go back to the session so that we finish today's class. The implications of money laundering, I mentioned that, so I've hidden the slides because I mentioned that the implications or the negative effect of money laundering not very much different from the negative effect of the crime of corruption, which I discussed in the previous session. So you refer to that, it's exactly the same. Now some critical reflections, and then we close today's session. I want us to reflect on two questions. The first one concerns what is called self-laundering. Self-laundering. So this is whereby authorities arrest and convict or charges somebody with the crime of money laundering when the person he has committed is also the person, he has also committed the predicate offense. So you have stolen a mobile phone, and you then sold it to somebody else so that, you know, people will not find you with this one. So you sold it to somebody else, you got the money. So you'll be charged with both the crime of stealing a mobile phone and the crime of, money laundering for selling the mobile phone. They'll say you were converting it, you were concealing it. So the question here is this crime justifiable in a democratic society, or it's double jeopardy? Double jeopardy, I mean that we are punishing the person for, twice for the same offense. So we punish the person for stealing the phone. We punish the person also for the crime of money laundering when it's simply one single act that you have committed. So the person is now being punished twice. That's what we call double jeopardy. So is self-laundering a crime that is legitimate, or it's a crime that violates the right of the accused? Because even the accused person does also have a right. One of the rights is that you don't get punished twice for a single offense, right? The second question I want us to reflect on is about us as young law students who will become legal practitioners one day. So I mentioned that we have an obligation to report clients committing money laundering if we are, we are carrying out certain transactions, not in all the work that we do as lawyers, but in other work that we do as financial advisors. If we help someone set up a trust, if we help somebody set up a charity organization, and we believe that they want to launder some money or to sponsor financing of terrorism, then we should report those clients to the PPTK. Is it PPTK? Is that a violation of our of the legal practitioner privilege or the confidential lawyer-client confidentiality? These are the two questions I want to ask to the group. Now, anybody who wants to volunteer and answer here?
By default saja, aja, nggak usah cari sebenarnya apa. Tapi kalau itu terjadi sama kalian, kalian pilih pendekatan etiknya atau mau bongkar yang mau. Terus cuma mau dapat trigger saja dari kalian.
Silahkan.
Jawaban
Tersebut mungkin aku bisa.
Ayo, Pat. Daripada saya panggil lama.
Okay. It seems the students have read too much today, so maybe what we can do is to give them this as homework, and if they can, then yes, send the answers at a later date. Yeah, maybe we give them, or we can set this as an exam question.
I think it's a brilliant idea.
Yeah, sure. Otherwise, I'd really like to thank those who contributed, those who participated, but also everybody for your attentive listening. If you have any questions now, this is also the time for questions. So any questions? Any questions based on this session, today's session? Okay, I guess there are none. And I would like to thank colleagues, students, thank you so much.
Thank you so much, Prosper, for the material. It was very attractive and interesting for us. Do you want to make your closing statement? Yeah, we are very grateful that you want to share your knowledge with us. We
Oh, yes.
apologize for some of the shy students.
Well, no need to apologize. And I understand, you know what, this crime of money laundering is even challenging, a daunting crime, even for practitioners themselves. They are also still trying to understand exactly why do we even need this crime? We already have other crimes. Yeah, yeah. When somebody is stealing, it's common knowledge that they want to use the money for something else. Why should we also charge them with money laundering? So it's still a crime that is emerging. And I'm very happy that the students, from the questions that they posed, they seem to be understanding at least the basics. And we'll share the slides so that they can also read in their own time and then get to understand this. One thing that I just want to mention as a takeaway for our students here is that you need to take this crime very, very seriously. Why? As I said, as law students, there is now an extra burden on you from the authorities to report, to help in, you have now been made enforcement officers, because every lawyer is now under an obligation to report, if they believe that their clients may be involved in money laundering. This is not for all our work. For some of the work that we do as lawyers, we are now required by the authorities to report. So this is a crime that we should take seriously. If we fail to honor that obligation, you can get deregistered as a lawyer. You can end up being arrested yourself or even paying a hefty amount of fines. So we need now to take this crime seriously. So this is an interesting area. And also as law students, maybe some of you are interested in knowledge, like us teachers. You may want to write a thesis in this area. So start now already to see which areas have not been discussed. So many areas have not been discussed in terms of the crime of money laundering in Indonesia. So start already to think of the dissertation that you will write in your final year. This is a very interesting area, and I will of course be available to help those who want to work or maybe write a short assignment on this. So I'm available, and my contact details are also on the slides that will be shared later. But this is my takeaway for you, message for you guys, and thank you again for your attentive listening.
Okay, thank you very much, Dr. Prosper. It was a very insightful lecture. We hope it's very kind of you to share these materials, and also would like to guide students who put interest in studying regarding money laundering. I hope that everyone, semoga teman-teman memanfaatkan kesempatan ini karena jarang-jarang ya dapat bimbingan langsung dari Dr. Prosper yang ahli di bidang money laundering atau TPPU. Thank you very much, Dr. Prosper. We will make sure that everyone do the assignment as you have been told, and we will share the assignment via Google Docs later on when it has been collected. Thank you very much.
Excellent.
Thank you very
Thank
much.
you so
Dr.
much.
Prosper. See you.
See you.
Ya, teman-teman sekalian, jadi ada 2 tugas ya yang minggu lalu dan minggu ini diberikan oleh Dr. Prosper. Jadi saya sudah koordinasi dengan masing-masing dosen di tiap kelas. Nanti kami akan kirimkan satu link ke Google Drive. Di situ ada 2 folder, ada folder materi tentang korupsi dan materi tugas tentang tindak pidana korupsi dan tugas tentang anti pencucian uang. Di dalamnya ada subfolder lagi kelas A, kelas B, kelas C. Nah, nanti teman-teman silahkan mengupload tugasnya ke sana. Kemudian untuk nama filenya langsung dituliskan nama dan juga NIM Anda masing-masing di dalam format PDF. Untuk tugas anti korupsi yang minggu lalu adalah terkait dengan pengalaman kalian berinteraksi langsung atau merasakan langsung yang namanya tindak pidana korupsi. Dan di tugas minggu ini terkait dengan pencucian uang adalah Anda diminta memberikan pendapat apabila dalam satu perkara Anda berada posisi sebagai seorang pengacara, di mana di salah satu kode etik pengacara adalah tidak boleh menyebarkan satu informasi yang sifatnya rahasia, tetapi informasi rahasia itu ada kaitannya dengan pencucian uang. Apakah Anda mau mengesampingkan kode etik tersebut dengan mengungkap pencucian uangnya, atau Anda lebih menjunjung tinggi kode etik advokat yang Anda miliki dan tidak membongkar pencucian uangnya? Itu dua tugas yang diberikan. Ada nanti kami kirimkan di grup WhatsApp kelas masing-masing untuk mengumpulkan tugasnya dalam format PDF. Jadi untuk tugas anti korupsi langsung masuk ke folder anti korupsi, tugas anti pencucian uang langsung masuk ke folder pencucian uang. Batas tugasnya adalah 1 minggu dari sekarang, baik yang minggu lalu dan yang minggu ini. Clear semuanya? Baik, untuk presensi kehadiran silahkan untuk kelas A ada di sebelah kiri saya di podium, kelas B ada di tengah, dan kelas C ada di sebelah sana. Kami ucapkan terima kasih atas kehadiran teman-teman. Untuk minggu depan, perkuliahan kembali ke kelas masing-masing dan diampu oleh dosen masing-masing. Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.